Hi, everyone. Thank you so much for joining us today. We're going to be talking all about non-competes and the recent changes that were passed in May, I believe, in the legislative session. So my name is Tracey Gutzmer, and along with my colleague, Lisa Netzer, who will be doing most of the chatting, we are going to talk again all about the non-competes. So first of all, just to introduce myself, again, my name is Tracey Gutzmer. I work with a dental consulting company. I'm a practice management coach. At Dental Consulting Company, we focus on all areas of an office, from hygiene to front office systems, as well as the doctor assistant relationship. So I specialize a lot in insurance, credentialing, most things along with the front office, and excited to be here today to chat with you about the non-compete changes. And with that, I'm going to turn it over to Lisa and let her take it from here.
Thank you so much, Tracey. Hello, everyone. My name is Lisa Netzer, and I'm an attorney in Minnesota working for True North Practice Transitions. We are a law firm that works pretty much exclusively with dental offices. We help buy and sell practices, write contracts, and I help with employment law handbooks. And this year, a lot of changes at the Minnesota legislature apply to a lot of small businesses. So we're really excited to bring this information to you and keep you up to date on where your handbooks and your employment law understanding needs to be for your office. So to get things started, we're going to jump right into non-compete changes. Effective July 1 of 2023, Minnesota no longer allows non-compete clauses in new employment contracts. It's really important to know that this applies going forward. If you have an employment contract that you signed in June of 2023 that has a non-compete in it, there is nothing in the statute that would say that that non-compete is not a legit non-compete and enforceable. However, this also applies to all sorts of contracts. So don't think that if you have an independent contractor agreement or a separation agreement or a severance agreement that you can stick a non-compete in there. That's not going to fly. No new non-competes unless you meet a very specific exception. And the one exception to this right now is non-competes for the sale of a business. So it makes sense if you are selling your business and the new buyer wants to protect the goodwill that they are paying a lot of money for, then they get to have a non-compete. And so those non-competes are perfectly allowable. However, a non-compete should not be in the employment agreement. It should be in part of the sale of the business agreement. Also, there are still restrictive covenants that apply to someone after they leave work for your business. One is a non-solicitation agreement, and the other is a confidentiality agreement. Both of those clauses are perfectly legitimate to have in your employment contracts. So make sure your employment contracts don't just have the non-compete. They also get rid of the non-compete. Make sure that they still have a non-solicitation and confidentiality provisions in those contracts. This is a change that is taking place in Minnesota, but it's also taking place all over the country. For quite a while, California and North Dakota did not allow non-competes. But at the same time that Minnesota adopted its prohibition against non-competes, the state of South Dakota, a very different political climate there, also said no non-competes for any healthcare workers. And their healthcare worker definition definitely includes dentists, hygienists, and others working in the dental office. So we're also seeing possible national trends towards this as well. I think we're just riding the front of the wave, but this is a change that's going to be coming to a lot of places in the near future. There is in this statute a choice of law provision, and that's a really important part of the statute. It basically says that if you live and work in Minnesota, you should not be subject to a non-compete. So if you work for a company that exists outside of Minnesota, let's say you have a Wisconsin dental service organization and you work at their satellite office somewhere in Minnesota, if you are living and working in Minnesota, this law still applies to you and you would not have a non-compete in your contract, or you shouldn't if you're signing a new one. However, if you are a Minnesotan who is also working in another state, there's a good argument to say that unfortunately you can be subject to a non-compete in those states at this point in time. The big money question for a lot of people, though, is that they have a non-compete and with a current employee, and is that still enforceable? The surprise for me in learning about this is that a lot of litigators have had trouble enforcing non-competes in the courts. The main issue is just court resources. When courts are truly backed up with things like criminal cases and really big divorce cases, other things, they don't have a lot of time for business cases. So these things have fallen to the bottom of the pile. If you think you're going to march into court and get a temporary restraining order based on a non-compete clause, that is hard to do. So don't be expecting it. However, that doesn't mean it's not a legitimate claim or that you couldn't enforce your rights under that contract. Just know that courts might not be super fast in enforcing those rights. So we'll also, over the next 5 years, the courts will have a chance to look at non-competes again in light of this new statute. Again, there's already a disfavored status to non-competes anyway in all states pretty much throughout the country. But in Minnesota, we'll see if having the statute on someone's side will push the courts to interpret that no one should have a non-compete, including retroactively. I don't see that yet, but a lot of people with a lot more money than dentists are going to be litigating this issue because there's a lot of money if you're a CEO of a big Fortune 500 company or a salesman for Medtronic or other things like that. These people will probably be the ones making the law happen, but we can expect a lot of action in the courts going forward. In other words, the lawyers will keep up and still be busy. All right. So one of the things I mentioned that you can have in your employment contract going forward is a non-solicitation agreement. And you think after over 100 years of Minnesota case law about non-solicitation agreements, we know exactly what that means, but it's not really clear. There's a question about whether accidental solicitation or general solicitation would ever violate a non-solicitation clause. The really easy case is that you have an employee who walks out the door and then sends a bunch of direct messages via text to all of your patients. Clearly a violation of the non-solicitation clause. But an employee who's simply out in the marketplace or exists on another website for a competitor down the street probably isn't in violation of the non-solicitation clause. So you need to make sure that your non-solicitation clause says no direct contact with current patients, and also non-solicitation clauses apply to your employees too. So make sure that an associate who is leaving isn't also taking staff with them. Make sure your non-solicitation clause covers both situations. My best recommendation for you if you have a new employee coming on is to make sure you've got that non-solicitation and confidentiality agreement in your employment contract. But another big takeaway is do not simply reuse contracts. If you have an active non-compete with a current employee and they ask for a change, say in their vacation time, don't simply pull up the contract, change the amount of vacation time they have in there, reprint it, and you both sign it again. If you do that, the employee is signing a non-compete after July 1 of 2023, and that means that that non-compete is no longer enforceable. You need to amend your employment contracts, and you need to have a form that says basically that all the other provisions in the original contract still are enforceable, but this little change is what we're going to make to the employment contract. So be careful how you proceed and protect your non-competes going forward. Now, I'll hand it back to Tracey.
All right. So the biggest thing that I'd like everybody to think about is, okay, now we have this non-compete clause, right? And it's gone away. So we need to control what we can control because there's nothing we can do about the fact that the non-compete clause is gone. So the first thing I want you to think about is what makes your practice different? What makes it attractive for an associate to not only come on board, but to stay with you? So what type of benefits or what is the environment that you provide for that associate. And obviously this extends to other employees as well. So with an associate though, depending on what they're looking for, do they want a mentor? So is that important to them? Do they want certain technology? Is continuing education and what you offer them, like being able to do with continuing education? Can they increase their scope of practice? There's all sorts of things within the office environment that you can control and make it attractive for that associate. We want that associate to stay, right? So we're going to be giving reasons to that associate that they don't need to look anywhere else because this is the greatest practice in the world and they have everything that they need right here. In addition to that, you need to look at the internal safeguards. And I know Lisa already covered a couple of these, so I'll just kind of go back over them briefly. But first thing I want you to think about is password protections, making sure that we have passwords protected throughout the office. And that is not only from key codes and door codes, right, but to our computer systems and anything else that requires a password. Also making sure that if an associate would leave, really any employee though, again, that though they're inactivated and things that need to be changed are changed, such as key codes, or if you guys had somebody sharing a password between an assistant and a doctor, things are changed so that you're protecting your information of your practice. Non-solicitation of employees and patients. I mean, Lisa really covered this extremely well, but making sure that we have that in place so that, I mean, we never want to believe that anything's going to happen, but things happen. So making sure that the assistant and the doctor that is leaving don't print off a list of patients and then are able to start soliciting those patients to their new practice, let's say. And then also making sure that you have a non-disclosure or a confidentiality form for your employees. And a lot of times this will come in some sort of HIPAA training about what you can disclose outside of the practice and what you can't. There's so many things that obviously you cannot disclose outside of the practice. So really just making sure that you have all of those systems buttoned up as a protection for you. So in conclusion with that, again, let's just kind of control what we can control. So, and from there, if you have questions on anything related to the non-compete, you have both Lisa and my information right here in front of you. So shoot us an email and we're happy to help out. Thanks so much for joining us today.
Thank you, everyone. Bye-bye.
Bye.